Hello, everybody. Wow, thank you. I know you're very excited about what's to come, and I'm very excited about looking at this packed room. Wow, how fabulous. We know the place to be on Friday night in D.C. Here we are. So I have, it seems to be such a fabulous job that I have. I have another special privilege, which is I get to introduce Peter Rubin, whom many of us consider to be the father of ACS. And I would say, feeling a little bit of sibling rivalry, because I think Peter Rubin's going to be the father of another child. So maybe we should congratulate Peter and Jennifer. So Peter, as we all know, is now an eminent member of the Massachusetts Appeals Court. But back in 2001, he was a distinguished constitutional law and criminal justice professor at Georgetown University Law Center. It was there that he led a group of law students, scholars, and lawyers in founding ACS and beginning to build what has become our vibrant network of progressives to counter the right-wing legal movement. So I hope you will extend a very, very warm welcome to our founding father, Justice Peter Rubin.
And I hope you'll join me in thanking Caroline Fredrickson and all the ACS staff for everything they've done to make this such a great convention. It is not often one gets to introduce a living legend. And among those in our shared profession, the law, there's no legend greater than that of our next speaker. I had the wonderful experience of serving for many years on the Georgetown faculty with Justice Ginsburg's late marvelous husband, Marty, and it is a special pleasure for me to introduce her, both because of her personal friendship and because of her early and long-standing support of ACS. Justice Ginsburg spoke at ACS's first convention right here in this room, and now she honors ACS at its 10th annual convention. ACS has no better friend, and I know that all the members and friends of ACS are grateful to you. Even before she took the bench, Justice Ginsburg had had a profound impact on the shape of American law. She was the first woman to become a tenured law professor at Columbia, and as the director of the Women's Rights Project at the ACLU, she won landmark decisions, including Reed v. Reed, in which she represented the appellant, and 5 of the 6 sex discrimination cases she argued before the Supreme Court, including the 8-1 decision in Frontiero versus Richardson, altering the course of American constitutional law and opening the path to the recognition of the equality of women under our fundamental charter. Appointed in 1980 by President Jimmy Carter to the United States Court of Appeals for the District of Columbia Circuit, she was elevated to her seat on the United States Supreme Court by President William Jefferson Clinton in 1993, and she has served there with distinction for almost 2 decades now. On the High Court, she has written significant decisions, like United States versus Virginia, requiring the Virginia Military Institute to admit women, and MLB versus SLJ, which held that impoverished individuals could not be denied the right to appeal the termination of their parental rights. Justice Ginsburg has also written important dissents in cases such as Ledbetter versus Goodyear Tire and Rubber. In that case, the court held that Lilly Ledbetter's claim for pay discrimination was barred because it expired 180 days after the decision to discriminate against her was made, even though she continued to receive in each paycheck a discriminatory wage. That decision was overturned by Congress, which amended Title VII in the Lilly Ledbetter Fair Pay Act of 2009 by votes of 61 to 36 in the Senate and 250 to 177 in the House. The theme of this convention is democracy at stake, and perhaps most significantly, Justice Ginsburg dissented from the court's decision in Bush v. Gore, in which by a bare 5-4 vote, the court stopped the counting of ballots to determine who had won the presidential election in Florida and thus the nation. She was also among the dissenters in another case that I know is of real significance and interest to all of you, Citizens United versus FEC, which allowed corporate independent expenditures in elections based on a conclusion that such expenditures, quote, do not give rise to corruption or the appearance of corruption, unquote. In a recent statement accompanying an order granting a stay of the Montana Supreme Court's recent decision in American Tradition Partnership versus Bullock, which presents a challenge to Citizens United, Justice Ginsburg wrote in a sentiment with which I know many, though of course not all of you will agree, that the court should, and I quote, consider whether, in light of the huge sums currently deployed to buy candidates' allegiance, Citizens United should continue to hold sway, unquote. I think as Americans, we all accept the truth of Dr. King's words, of which Senator Harkin reminded us this morning, that the arc of the moral universe bends toward justice. Here on earth, the work of bending that arc requires the concerted effort of human hands working together. No stronger hands have been devoted to that task than those of our next speaker. Because of her, we live in a better, fairer, and more just America than we otherwise would. Ladies and gentlemen, Justice Ruth Bader Ginsburg.
Thank you. Please sit down. Enough. Please be seated. That was a splendid introduction, but the truth is I have had more than a little bit of luck in my life to be born when I was, to be a lawyer when the women's movement came alive in the late 60s and early 70s, and could lend my whatever skills I had as a lawyer to nudge that movement along. Well, I think many of you know it is now flood season at the court. So all I can offer this evening is an impressionistic view of what life has been like at the court in the 2011 to 2012 term. And in doing that, I will borrow heavily from the annual report I made to my circuit, the Second Circuit, at its judicial conference last week. Some years ago, a former law clerk turned law professor, who perhaps is in this audience tonight, ranked the justices by the number of laughs they provoked at oral argument. He rated me, his former boss, the least funny justice who talks. I remained in last place this term with only 2 laugh lines. A published tally, for which I do not vouch, rated Justice Scalia first among funny justices with 63 laughs, Justice Breyer next with 47, the Chief a distant third with 26. But it may be a promising sign that the New York Times picked up my best laugh line this term. It was in a case called Zivotofsky against Clinton. It concerned an act Congress passed permitting U.S. citizens born in Jerusalem to designate Israel as the birthplace shown on their passport. The president resisted the law, urging that it intruded unconstitutionally on his foreign affairs prerogatives. In defense of the legislation, Mr. Zivotofsky argued that the statute did not trench on presidential ground. All it did was to give parents a choice. Your argument would be stronger, Justice Kagan suggested, if U.S. citizens born in Jerusalem could similarly choose to list Palestine on their passports. Oh, they can, counsel responded, if they were born before 1948. Well, Justice Kagan said, you have to be very old to say Palestine. I intervened on behalf of persons aged 64 and over, mindful that next year I will turn 80, God willing. Not all that old, I told my youngest colleague. In the past years, lawyers and journalists have paid rapt attention to remarks from the bench concerning our workload, which some misguided commentators think is too light. You should stay with me this weekend and you will see. Justice Breyer quipped defensively, I'm not trying to get out of work. Instantly stirred, Justice Scalia volunteered, I'd like to get out of the work, to tell the truth. Argument often proceeds at a clipped rate so rapid that it is sometimes hard to get a word in edgewise. Justice Kagan, as the junior justice, takes great care not to step on the questions of her senior colleagues. But one time, she tried to enter the fray, only to be silenced by louder voices. At last, Justice Breyer instructed counsel, go back to Justice Kagan. Don't forget her question. Many minutes had elapsed by then, and Justice Kagan smiled and said, I've forgotten my question. See what it means to be the junior justice. The term has been more than usually taxing. Some have called it the term of the century. Perhaps that explains why the funniest justice called counsel's argument extraordinary no fewer than 10 times. Some of us think that Justice Scalia's extraordinary is perhaps becoming rather ordinary. The argued cases this term numbered 80. That's a decrease of 6 from last term. But the decline was offset by per curiam decisions issued in cases decided without full briefing or any oral argument. Summary dispositions of that kind already number 10, more than twice the number issued at this time last year. Too many? I leave that for you to judge. To date, opinions have been released in 58 of the 80 argued cases. One petition was dismissed post-argument as improvidently granted, and 21 cases remain to be announced before the judges scatter for the summer. The court split 5-4 or 5-3 with one justice recused in 9 of the 58 cases so far handed down. In comparison to that close to 16% sharp disagreement record, we agreed unanimously on the bottom line judgment in 26 or 45% of the already announced cases, and in 20 of the 26 opinions as well as judgment were unanimous. Quite collegial, would you not say? Well, as one may expect, many of the most controversial cases remain pending, so it is likely that the sharp disagreement rate will go up next week and the week after. I will now describe rather quickly some of the most watched cases. First, United States against Jones, which presented a 21st century Fourth Amendment question. If police attach a GPS tracking device to your car and then use it to track the car's movements on public streets for several weeks, have you been searched within the meaning of the amendment? The court's unanimous answer, yes. Justice Scalia, for the majority, observed that the framers would have been aghast at the thought of a constable hidden beneath a coach, recording with quill and ink every turn the horse made. The tracking device physically invaded private property for the purpose of obtaining information, he explained. Indubitably, he said, attachment of the device caused a search within the meaning of the Fourth Amendment. Physical invasion of private property, Justice Scalia's main theme, was not the motive sounded in Justice Alito's concurring opinion. Writing for 4 of the justices, he said that the long-term monitoring of Jones's car tread on his reasonable expectation of privacy. At the circuit stage, the Ninth Circuit was on the losing side of the split, dissenting from the denial of rehearing en banc by that court. Chief Judge Alex Kosinski got to the heart of the matter. There is something creepy and un-American about such behavior. He wrote, to those of us who have lived under a totalitarian regime, there is an eerie feeling of deja vu. The meaning of the Fourth Amendment was again at issue in Florence v. Board of Chosen Freeholders of Burlington County. Florence concerned the practice in New Jersey county jails of subjecting all arrestees to strip searches before admitting them to a jail's general inmate quarters. Florence was arrested for failure to pay a fine. Wrongly, as it turned out, he had in fact paid what was due. Transferred from one jail to another, he was strip searched twice. And after all charges against him were dropped, Florence sued the jails in which the searches occurred, seeking damages under Section 1983. By the time Florence's case reached the Supreme Court, 8 courts of appeals had already held that strip searches of persons arrested for minor offenses were impermissible, absent reason to suspect that the person arrested was concealing contraband. In Florence, the Third Circuit disagreed and upheld the jail's routine practice. Justice Kennedy, writing for the court, affirmed the Third Circuit's decision. The strip searches at issue struck a reasonable balance, the majority held, between inmate privacy on the one hand and prison safety and administration on the other. Justice Breyer dissented, joined by Justices Sotomayor, Kagan, and me. In our view, a strip search is inherently harmful, humiliating, and degrading, a serious affront to human dignity and to individual privacy. As there was no cause to suspect that Florence was concealing drugs or otherwise presented a security risk, we judged that the searches to which he was exposed were unconstitutional. A third case, FCC against Fox television stations, asks whether the FCC's current indecency policy violates the First or Fifth Amendment. The Paris Hiltons of this world, my law clerks told me, eagerly await the decision. It is beyond my comprehension, I told my clerks, how the FCC can claim jurisdiction to ban words spoken in a hotel on French soil. The case came to us on a return trip. In Fox 1, we held that the FCC did not violate the Administrative Procedure Act when it altered its longstanding indecency policy to regulate the broadcast of fleeting expletives. The we did not include me. I dissented, agreeing with Justices Stevens, Souter, and Breyer. The court remanded the case to the Second Circuit to consider, in the first instance, the constitutionality of the FCC's newly minted fleeting expletive policy. The Court of Appeals did so and struck down the FCC's broadcast indecency policy in its entirety, not simply as applied to fleeting expletives. The policy, the circuit panel majority concluded, was void for vagueness. We accepted the government's petition for review. During the argument in what we call Fox 1, speculation abounded whether counsel for Fox Television would speak the F and S words before the Supreme Court, as he did before the Second Circuit. He did not. This time, in Fox 2, counsel for ABC Television one-upped his colleague. ABC's counsel first reported that there had been 9 seasons of unsanctioned NYPD Blue episodes that had fleetingly displayed bare buttocks. He then pointed to all the bare buttocks carved in the friezes that adorned the courtroom walls. A gesture perhaps worth 1,000 words. A fourth case on my select list will be re-argued next term, Bell against Royal Dutch Petroleum Company. It originally presented this question: can corporations be sued under the Alien Tort Statute? The Second Circuit held they cannot. And in a case argued the same day as Bell, Mohammed against Palestinian Authority, we held that under a much newer and differently worded law, the Torture Victim Protection Act, corporations are not amenable to suit. Respondent raised an alternative ground for affirmance in Bell. The Alien Tort Statute should not apply at all to conduct occurring in a foreign nation, was the argument. Some of the justices showed a keen interest in pursuing that theory, and soon after argument, we ordered the parties to brief whether and under what circumstances the Alien Tort Statute provides a claim for relief for violations of the law of nations occurring outside the United States. Next, a pair of cases, Lafleur v. Cooper and Missouri v. Fry. Both presented this question: does the Sixth Amendment right to effective assistance of counsel extend to the negotiation and consideration of plea offers that the defense rejected or allowed to lapse? Justice Kennedy, writing for the majority, held that the Sixth Amendment right does attach. Galen Fry had been charged with driving with a revoked license. The prosecution offered a choice of 2 plea bargains: one, a recommended 3-year suspended sentence plus 10 days in the county jail; the other, 90 days to be served on a lesser charge. But Fry's attorney did not tell Fry that the offers had been made by the prosecution, and so both of them lapsed. Fry later pleaded guilty without any plea agreement and was sentenced to 3 years in prison. When ineffective assistance of counsel causes the failure to accept a plea offer, the majority held, and further proceedings then lead to an outcome less favorable than the proffered plea bargain, a defendant may be entitled to a remedy. In dissent, Justice Scalia pointed out that many countries forbid American-style plea bargaining, at least in serious cases. These foreign systems, Justice Scalia said, adhered to the admirable belief that the law is the law and those who break it should pay the penalty provided. Has anyone in our Congress noticed that Justice Scalia is not allergic to foreign law side glasses? Next, a pair of cases, Miller against Alabama and Jackson v. Hobbs, prompted by the court's 2010 opinion in Graham against Florida. Graham held that the Eighth Amendment's prohibition on cruel and unusual punishment bars life without parole as a sentence for a juvenile convicted of a non-homicide crime. Miller and Jackson present these further questions. First, does life without parole, can it be imposed on a 14-year-old who is convicted of homicide? Does that violate the Eighth Amendment? And if such a sentence can be imposed on a juvenile at all, does it violate the Eighth Amendment when the sentence is decreed under a mandatory sentencing scheme that allows no consideration of the child's age? Finally, two cases that attracted the term's largest headlines, also knee-high amici briefs. I will mention first the case argued on the term's very last day, Arizona against United States. In April 2010, Arizona enacted legislation titled Support Our Law Enforcement and Safe Neighborhoods Act, or SB 1070. Its provisions are designed to discourage and deter the unlawful entry and presence of aliens and economic activity by persons unlawfully present in the United States. Arizona described its policy as implementing attrition through enforcement. Before the law took effect, the United States sued Arizona, alleging that the Federal Immigration and Nationality Act covered the field and preempts SB 1070. The district court, finding that the United States was likely to succeed on the merits, preliminarily enjoined enforcement of 4 provisions of the Arizona Act. The Ninth Circuit affirmed, and the state petitioned for review, urging that Arizona's law complements and does not conflict with federal law. One indication of the importance of the case, 5 states have passed similar legislation, and bills modeled on the Arizona scheme have been introduced in most other states. Last but surely not least, the affordable health care cases. No contest, since the court invited new briefs and arguments in Citizens United, has attracted more attention in the press, the academy, the ticket line outside the Supreme Court, a line that formed 3 days before oral argument commenced. Some have described the controversy as unprecedented, and they may be right if they mean the number of press conferences, prayer circles, protests, counter-protests going on outside the court while oral argument was underway inside. Arguments consumed more than 6 hours, spanning 3 days, remarkable in modern times, but recall that in one of the cases prominently cited in the healthcare briefs, McCullough against Maryland, oral argument in 1819 ran on for 9 days over the course of 2 months. The 3 cases challenging the constitutionality of the Health Care Act present 4 questions. First, the first has 2 parts. Does Congress have the authority under Article 1 of the Constitution, either the Commerce Clause or the power to tax and spend for the general welfare, to enact the so-called individual mandate? And second, if the individual mandate requiring the purchase of insurance or the payment of a penalty, if that is unconstitutional, must the entire act fall? Or may the mandate be chopped like a head of broccoli from the rest of the act? Third, does the Act's expansion of Medicaid exceed Congress's spending power? And fourth, the big question inviting the answer everyone is waiting for: do federal courts lack jurisdiction to entertain a pre-enforcement challenge to the individual mandate in light of the Anti-Injunction Act of 1867. That act prohibits any person from suing the federal government to restrain the assessment or collection of any tax. To accommodate an audience enormously larger than our courtroom will hold, we released same-day audio recordings of the arguments. And though our deliberations are private, that has not dissuaded the media from publishing a steady stream of rumors and fifth-hand accounts. My favorite among press pieces wisely observed, at the Supreme Court, those who know don't talk, and those who talk don't know. And nevertheless, a rumor circulated that the opinion hand-down session on May 24th would reveal the outcome of the healthcare cases. Rumor followers attended the session anticipating announcement of the momentous decisions. They got their just desserts, and they learned from the only decision announced from the bench that day that Section 8B of the Real Estate Settlement Procedures Act does not prohibit all unearned fees. It bars only unearned fees split between two or more persons. I have spoken on more than one occasion about the utility of dissenting opinions, noting in particular that they can reach audiences outside the court and propel legislative or executive change. And Peter mentioned a most fit example, the dissent I summarized from the bench in 2007 in Lilly Ledbetter against Goodyear Tire. As he said, and as most of you know, the case involved a woman who worked as an area manager at a Goodyear tire plant in Alabama. Her starting salary in 1979 was in line with the salaries of men performing similar work, but over time, her pay slipped so that by the end of 1997, there was a 15 to 40% disparity between Ledbetter's pay and the salaries of her 15 male counterparts. She filed charges of discrimination with the EEOC, and eventually a jury resolved her Title VII suit favorably, awarding her back pay and damages. The Supreme Court nullified the verdict. Ledbetter filed her claim too late, the court held. It was incumbent upon her, the court said, to file charges of discrimination each time Goodyear failed to increase her salary commensurate with the salaries of her male peers. Any annual pay decision not contested within 180 days, the court ruled, became grandfathered beyond the province of Title VII to repair. The court's ruling, I wrote for the dissenters, ignored real-world employment practices, the practices Title VII was meant to govern. Sue early on was the majority's counsel when you may not know that men are receiving more for the same work. And of course, you would likely lose such a case because the defense would be, had nothing to do with her gender. She just didn't do the job as well. A case that can't be made when somebody has been on the job getting good performance ratings for 20 years. But if you wait until your case is fully baked, when the disparity is steady and large enough to enable you to mount a winnable case, you will be cut off for suing too late. That situation, I urged, could not have been what Congress intended. The ball is now back in Congress's court, was my bottom line. The legislature may act to correct the court's parsimonious reading of Title VII. And so 19 months later, the court passed the Lilly Ledbetter Act, overruling the court's decision, a decision I considered entirely out of touch with the real world of work. The court's first opinion of the current term did not receive similar notice. It was titled Cavazos against Smith, And there I addressed my dissent to a different audience. Shirley Reese Smith, abysmally represented at her trial, was convicted of shaking her 7-week-old grandson to death. Her sentence, 15 years to life. The Ninth Circuit on habeas review held there was no convincing support for the state's theory that the infant died of so-called shaken baby syndrome. The Supreme Court had twice remanded the case to the Court of Appeals, admonishing the Ninth Circuit each time to heed AEDPA. The third time round, the Court of Appeals struck out. The Supreme Court summarily reversed the circuit's grant of habeas relief and told the Court of Appeals not to tamper with the state court's conviction. Justices Breyer and Sotomayor joined my dissenting opinion. The court's summary disposition of this case, we said, was a misuse of the court's certiorari discretion. What is now known about shaken baby syndrome, we noted, casts grave doubt on the charges leveled against Smith, and uncontradicted evidence showed she possessed no danger whatever to her family or anyone else in society. In December of last year, Smith filed an application for commutation of sentence with California Governor Jerry Brown. The application borrowed some words from the dissenting opinion in the court. On April 6, Governor Brown commuted Ms. Smith's sentence to time served, noting significant doubts about her guilt. It was the governor's first grant of clemency in his current term. Justice at last prevailed. Don't you agree? Thank you. Thank you.
So I'm not sure who that law professor who is calculating how funny the justices are, because I think we are all pretty well aware that Justice Ginsburg has a fine sense of humor and a very incredible wit. So perhaps we can give her one more round of applause for coming in the middle of an incredible time. What a privilege that was for us all, I think I can say, without any dissent in this room. And poor Justice Ginsburg now has to go and work. But we actually have a reception that follows. But before we break into the reception, I want to remind everybody that we start again at 9 a.m. tomorrow morning, where we have a plenary panel on the aftermath of Citizens United, our favorite bugaboo. So please be here on time for that. It will be right in this room. So now we're going to go to our reception in the Congressional and Senate rooms, where we're going to hear from our next guest, Richard Cordray, who we are also very excited to have. But before you arrive at the reception, I want to remind you one more time, we have a silent auction that has some splendid items of all kinds: music, books, paintings, by my mother. So Supreme Court bobbleheads. So this auction is going to end during the reception, so please go out and bid and enjoy yourself for the rest of the evening, and we will see you again in the morning.